what goes on here or not. So I'm just trying to tease that out now. So,
Right. No, this is a very good question. Thank you. And it's one of the difficulties of trying to come up with a taxonomy that is conceptually coherent, as we're saying, which is a challenge in a sense when we face such a broad and somehow new category. One first element is, of course, temporality. I think you also suggested it. So I'm trying to discuss laws that either by being passed in the very momentum of the discussion of fake news / disinformation, or by being revamped in the views, somehow try to tackle this problem directly. Holocaust denial laws are a bit more, in the sense of the political significance, a bit peripheral on this, because it's an older discussion in a sense. It's also been settled better in a sense. There is case law from both the Human Rights Committee and I believe the European Court of Human Rights.
Yeah, loads. Like there are 5 or 6 cases from the ECH of Holocaust denial.
But one of the elements, so help me clear, Costi, if I'm mistaken, one of the elements that the court and also the Human Rights Committee find in deciding that Holocaust denial laws are compatible with Article 19 is
yes.
the scientific backing to it. So the fact that it's a scientifically settled debate. There is another decision which I must apologize because now off the top of my head I can't recall it. But there is another decision, I believe, from the US Supreme Court which engages with a similar case of a historically disputed debate and finds the law that tried to make that type of argument illegal incompatible with the protection of freedom of expression because
you might be talking about Perinchik case. Perinchik is about Armenian Holocaust denial case. It's Perinchik and Switzerland. And indeed, like since the court ruled that because Armenian genocide is not as established as Holocaust, then the protection afforded by the European Convention might be different.
So I understand it's a very fine distinction here. But in the case of Holocaust denial, what it seems to me, most of the decisions elaborate with the element of the scientific / historical process to establish the truth. When it comes to news media, traditionally, truth goes down, in professional media, truth goes down to a process of accuracy. Self-regulatory mechanisms, professional guidelines for the news industry don't engage with truth as the final outcome of the process of crafting and disseminating news, but rather focus on the accuracy of the process and the excuse factual mistakes in that case. So because in the news media, traditionally, truth is conceived as a process and goes down to the respect of professional guidelines, in the accuracy of gathering information and disseminating it. Whereas in the case of Holocaust laws, truth is defined as the final outcome of the scientific debate in establishing historical facts. It seemed to me, even though the words truth and falsity appear in both cases, the perspective is slightly different. The perspective is more on the process in the case of news media, and the focus is more on the outcome, on the established truth in the case of historical debates. I don't know if it answers. I think it's extremely confused.
but I'm going to again push you a little bit harder on that. So if we put the Armenian case alongside the Holocaust case, the Armenian case on the rendition here is that it's less settled. Whether you want to call it scientifically or historically, which in itself raises a whole full set of issues, right? So, I mean, both historians and scientists would never let you get out of a room. But let's accept the conflation for a minute. And so the Armenian case is not scientifically settled, and therefore, in principle, the Armenian case would belong on your slide. Whereas the French Holocaust case you describe as settled because there is case law. So it seems to me that your implicit conceptual standard has some court somewhere convinced itself that this thing is settled as false. Now, the problem conceptually with that is, of course, that the whole period in this temporality of 2016 to 18 is where all sorts of knowledges of that very nature are in refreshed dispute. So it strikes me as this has particular examples of a problem that starts high up your presentation, where you didn't quote the Oxford English Dictionary or Webster's Dictionary, if we want to be mid-Atlantic or transatlantic, but you did say that NATO had picked up on the question of malinformation, which is in particular a weird thinking. So in other words, leaks are part of this problem, in a sense because NATO says so.
No, wait, no, leaks. So leaks were mentioned in the Council of Europe report as examples of information that can be harmful, but not false. And so it falls outside the scope of this information as understood by the Council of Europe.
And so in classical terms, the idea that something is harmful but truthful would, and you went back to the free speech jurisprudence, right? There's a whole other quagmire there, like from which we would never emerge. So even the obscenity category that you mentioned in passing, in the US free speech jurisprudence, it's very hard to get anything into that. So it's very hard to find parts of speech that are actually exempt from protection, right? So if we double clicked on your US constitutional analysis and then try to retranslate it back to the European analysis, I think you'll find the detour is probably not worth the hernia that you're going to get on the way across the Atlantic, because I don't think so I'm just concerned that I'm not really feeling where the framing of what gets onto your chart is coming from yet.
I must admit, it's extremely helpful, and I'm very thankful. I am getting slightly lost. So your concern is with the solidity of the analytical framework in picking up the cases.
Yeah. Why are these examples on your chart, but others not? The Armenian example, the French Holocaust example. There seem to be different ways to explain inclusions and exclusions.
Yes, definitely. So I think I don't have. I will note it down and I will reflect on it more. As I said, this is work in progress, so any feedback of this kind is very much appreciated. There is an element of political engagement. So these are one first element to decide what makes to the sample is laws that are relevant in this moment in the political debate to grapple with the problem of disinformation. And from a political perspective, the case of Holocaust denial laws has been brought up by some legal scholars, but if you look at practical measures that are being trying to be, that lawmakers and policymakers are trying to implement, the references to case of Holocaust laws are not being so prominent unless it's something which is also possible, of course. So in the sense, that's a slightly different conversation from the practical and political perspective. The second and more fundamental reason is that, as I was saying before, Holocaust laws and media self-regulation understand the element of accuracy and truthfulness in different ways. More of a process for the news industry and more of the outcome of the method. You're right, history is not, and that's also disputable. History is not a hard science, definitely, but nonetheless, historians do apply an academic method. And so the way in which historical truth is established is different than the ways in which truthfulness or accuracy is established in the news industry. And I'm not convinced, although it's something I need to go away and think about, whether the parameter for historical accuracy or truthfulness would also be so relevant or so applicable to the case of accuracy in news reporting. I apologize for I was replying to your answer with another doubt or with a counter, to your question for a counter question. But to me, the concern at the moment is that possibly the processes in which historical truth and accuracy in the news media are established are not the same. And so I don't think the two groups of laws can be so easily discussed together for the purposes of this. I don't know if this explains.
Yeah, no, I think you should.
Sorry?
I think you should go on.
I think it was another hand.
I just wanted to sort of say that I would have seen what you're talking about, specific aspects of stuff that is already up there. You know, the Holocaust of harm would be a specific aspect of perhaps an incitement to nation, an incitement to
In France?
In Germany.
I'm talking about France.
You're talking about the taxonomy of the whole slide. I just sort of see what you're saying.
No, I'm asking why the French Holocaust law is not up there and why South African hate speech, a specific example, is not up there. That's my question.
Okay, yeah. It just seems to me that there's a different level of abstractness on the slide that just could be.
So the Holocaust law is abstractly present in the fairness of the electoral process. Is that what you're suggesting?
Yeah, again,
Okay.
No, Richard, I wasn't saying. Thank you for this contribution. No, it wasn't. No, I'm not saying the Holocaust law is abstractly present. I'm saying Holocaust law is perhaps on the side or peripheral to this debate, but not essential because
those are different.
Right? Sorry?
Those are different.
Yeah, I think what I'm saying.
Yeah, yes. But my point was, Holocaust laws engage with the question of truthfulness in a different way. Where was I?
Russia.
Sorry, Russia. Yeah, haha. This law. So the example of the Russian law, which is again a news aggregators law from last year, is also interesting because it provides a mechanism in which large platforms have an obligation to take false content down. And it also gives the Ministry of Mass Communication the power to order platforms to take content down or to fine them in case they fail to comply with this order, but doesn't specify the relevant harm, the relevant protected interests. So in this case, it would be, so this is one end of the spectrum where legislators even fail to engage with the question of harm. Egypt is an example of a combination of pre-existing laws in the criminal code and new laws that spell out the mechanisms to implement the prohibitions. The criminal code in Egypt includes a provision that punishes the publication of false news, data or rumors that can perturb the general peace, spread fear or damage the public interest. And again, there is a newer law in Egypt that now extends this provision from the criminal code to any social media accounts with more than 5,000 followers. So in this case, there is an interesting attempt to bring social media users with large follower bases under the same regulatory framework as professional news media. Then there's the example of Bahrain, where the criminal code punishes the spreading of false or malicious news. It's interesting they say that, at least the English translation says or, false or malicious news, as if falsity and malice weren't necessarily the same thing. The spread of false or malicious news abroad, if such information harms the financial confidence in the state, its prestige, or its interest in a broader sense. Then we have a few examples from the Asian continent. China, there is this new cybersecurity law where Article 12 punishes any person, provides that any person or organization needs to use social networks in respect of the law, and in particular, they must not endanger national security, national honor, national interests. They must not incite subversion of national sovereignty.
They must not advocate for ethnic hatred or ethnic discrimination, disseminate violence, obscene sexual information, create or disseminate false information to disrupt the economic or social order, or information that infringes on the reputation, privacy, intellectual property, or other lawful rights. This is possibly the broadest identification of relevant harm that you can find, and it's interesting how here both private interests and public policy goals are conflated together. And then there's other examples with which I will engage a little more in detail. How much time do we have left, Kostya?
Well, we have until 3 o'clock, but,
until 3 o'clock, but we'll
you know, like, be reasonable.
Be reasonable. Are you suggesting I would be unreasonable otherwise? A few of the most interesting examples. The Malaysian anti-fake news bill that's been discussed at the moment with controversial fortune. It's not clear whether it will eventually make it, but Article 19 it engages with the question of what constitutes fake news more than the other examples. So in this bill, there is an engagement with what constitutes falsity, and especially specify that falsity can refer to both relevant news, information, data set, or styles of reporting. So they have a broader definition of what constitutes news, but on the other way around, they fail to pinpoint, they fail to look at a clearly defined interest, because they speak of individuals and business reputation. And then perhaps as an example of another very broad definition of the relevant harm, we have the example of South Africa in the Cybercrime and Cybersecurity Bill of 2017, which refers to information that is inherently false in nature. Information that is inherently false in nature and can cause mental, psychological, physical, or economic harm. So let's try and make sense, if possible, if we may, of these different approaches to defining the relevant harm in these laws. A few examples engage with the so-called right of the others listed under Article 19, in particular with the protection of reputation and privacy. Admittedly, it's not many. Most of the laws engage with public interests rather than individual rights. But it's interesting in this case to see that in the case of China, reputation and privacy are lumped together in the same provision, and traditionally, at least the way we understand concepts of reputation and privacy, they have two very different types of engagement with falsity. In our idea of a breach of privacy, the falsity or truthfulness of the information that's revealed to the public is usually relevant. It's information that shouldn't have been given to the public, whether or not it was false or true. Whereas falsity is very much the key in the case of defamation laws, because we define defamation as information that harms the reputation, but it's also false. So it's interesting to see how in this whole debate of fake news, reputation and privacy are somehow taken together in some cases. The German law also provides for the same type of response that's requested from intermediaries when either reputation or privacy are brought to the fore. It will be possibly interesting to see whether this will bring the two categories to come closer to each other in the next few years. But this is a minority. The path down to reputation and privacy is really the minority of examples. Most of these examples engage with different public-related interests, Again, another minority case is what we can call treason laws, laws of lèse majesty, laws that engage with disrespect of authority. Again, the examples are from Bahrain, where the prestige of the state is identified as one of the potential harms. Philippines, the interest or credit of the state. Again, it seems to fall under that category. Yes?
In terms of temporality, you've just gone back to the very beginnings of time. The first constraint, the very name, let's say, majesty. This is that there's nothing more ancient than the origin of that. So there was one thing about the French example was legislation from 2 weeks ago. Laissez majesté in terms of temporality is medieval. I'm interested in again just as a taxonomy, which is that's what it says on the tin, that taxonomy, and I just am increasingly lost for what the conceptual logic is.
So if I may try and clarify that. One thing are the laws that I'm trying to discuss. So yes, these are laws that have been passed or are being passed as we speak. And then I'm trying to discuss these laws against the background of the existing framework provided by Article 19 and different categories of limitation. So the categories are pre-existing, for sure. So treason laws as a category exists. If any of these laws amounts to an example of treason law, is it compatible with Article 19 or not? And I'm trying to unpack this. The different categories, which are the prism through which I'm trying to look at these laws, for sure, are established categories that have existed for a number of years, decades, centuries, whatever it is, depending on different cases. The laws, which are what I'm trying to discuss, yes, they are new instead. I'm discussing new laws through the prism of the existing categories.
Yeah, the French law doesn't have a pre-existing category, right, on their own account.
Exactly.
So that's brand new, right?
Yeah, well, I'm trying to engage with it, and I will try and demonstrate with use of a couple of decisions from the Human Rights Committee that it is possible to consider electoral fairness as part of both the rights of the others and public order, because the Human Rights Committee has engaged with similar but potentially relevant cases in the past. So yes, electoral fairness, the way it's spelled, is a new interest we haven't really engaged with so closely as the French law calls us to do. But it's possible to bring it back under the two umbrellas of rights of the others and public order. These others engage with pre-existing categories, and I'm trying to see whether they can be considered good examples of legislation compatible with Article 19 or perhaps not. For instance, in this case, if we consider these as examples of lèse-majesty or treason laws, they are in principle compatible with Article 19. This is what the case law of the Human Rights Committee tells us. These types of laws are in principle compatible with Article 19, but provided that state authorities need to demonstrate closely the nature of the threat posed by the speech. So this is a requirement that the Human Rights Committee has made in assessing the compatibility of any specific laws, treason laws with Article 19, fine principle, but the state authority will need to demonstrate the specific threat posed by the speech. And in the case of something as volatile as the moment as fake news and disinformation, it is unlikely that any state authority would successfully argue for a specific threat coming from any of the examples of fake news that we are used to. So, examples of treason laws, good in principle, at present unlikely to pass this stricter scrutiny of clearly identified existing risk, but this is something that's possibly
fluid at the moment. It needs to see how the conversation will evolve also at the political level. But it's unlikely that these examples, these harm, will make any of these laws to be found compatible with Article 19. Then we have all these different examples of wordings that in different ways engage with what we could consider public order. Some of them seem to go a little bit further than we are used to see. For instance, there's examples of laws that also identify the harm in panic. Fake information that causes panic in the public, in the example of Thailand, in the example of Egypt. It also talks of speech that spreads fear, that spreads fear. The same here in Ghana, speech that causes fear and alarm the public. These seem to be broad brush qualifications of the protected interest. Although, again, the Human Rights Committee in the past has accepted the case of speech spreading mass panic, has accepted the case of a statute limiting speech that spreads mass panic as compatible with Article 19. Although what the Human Rights Committee also does traditionally in these cases is to, whenever a broader definition of what constitutes the public order is accepted, then usually the third part of the test, the proportionality test, gets stricter. So there is this element of balance between the two. So if before I was saying that under this framework that the Council of Europe and other institutions are pushing forward at the moment, the part of the test that deals with identification of the relevant harm is likely to regain prominence. Nonetheless, we must be alert to the fact that these are broad brush categorizations of the public order. And again, state authorities will need to demonstrate the proportionality of the limitations. The element of proportionality is also something that we will engage with in a second when we see the case of the French law. And it's unlikely that any of these measures that ask for content to be taken down can be considered proportionate. What else can be done that is proportionate? We do have a handful of decisions from the Human Rights Committee that engage with the question of the fairness of the electoral competition. The most relevant one is Sheshetko versus Belarus. Are you familiar with this decision?
So it's the different committee.
So you don't care about it at all? You don't care about it at all. The Human Rights Committee found that states are under an obligation to prohibit any intimidation or coercion of voters, and that laws that implement this principle would constitute a lawful limitation to the right to freedom of expression. Whereas if voters were invited to boycott an election, a law that would limit this type of message would be incompatible with Article 19. Clearly, any example of fake news doesn't equal a form of coercion or inhibition of the voters. But the rationale helps us here, I think. The distinction between the two cases, a law that limits forms of coercion is compatible with Article 19. A law that prohibits calls for a boycott is incompatible with Article 19. It's because in the first case, a coercion clearly limits the right of the others, the right to vote, the right to the fair process of voting under Article 25. of the ICCPR. Whereas a call for a boycott is a form of legitimate political speech that tries to convince voters to exercise their own political right not to vote. So in one case we have political speech, which is protected. In the other case, we have an exercise of freedom of expression, an exercise of speech that hampers one existing right in the ICCPR, such as the right to free elections. And this is the difference that the committee has made in that case. This rationale could be applicable also to the case of fake news. Can we say that fake news are a form of speech that hampers the possibility of the fair electoral process, equality of arms in the electoral process? It's not as straightforward, but there is a potential argument that the committee has already put forward that could be reused in this case. There is another decision that is also relevant here, which is Jong Chioy versus the Republic of Korea, which has gone down a different path and has found that a law restricting speech for a limited period in advance of an election does not seem ipso facto to fall outside the aims contemplated in Article 19, paragraph 3, so found that there is a relevant interest under the protection of the public order in limiting speech that hampers the electoral process before the election takes place. So we have here two different rationales. Protecting the right to vote under Article 25, protecting the public order under the third paragraph of Article 19. In this last decision, the Human Rights Committee also engaged with the question of proportionality and found that the measure taken by the government was disproportionate because it limited communications for a period of 23 days before the election. And that was disproportionate in the opinion of the Human Rights Committee. So the French law that takes a window of 3 months to take down false content, it's unlikely again to pass the proportionality test if in the case of that decision 23 days were already considered too much. Again, this is very much a context-based type of decision, so it's difficult to make this call. But if the 3 months window raises some concerns in terms of proportionality, nonetheless, the case of the Human Rights Committee gives us two possible hints in the direction of considering fairness of the electoral process, a legitimate goal for a government to pursue. I also want, in the last few minutes, because I realize I'm running late, but if I can take 10 more minutes, I would like to engage with some different examples, different measures that states are trying to take. So this wouldn't be legal measures in the same way as we have discussed them so far, but it's more policy-related measures. In this case, the establishment of task force, independent bodies that somehow deal with the question of disinformation, by and large, by trying to spread awareness of the problem through the public, by engaging with awareness-raising projects, by engaging in fact-checking, so trying to counter the spread and the negative impact on disinformation in these different types of ways, rather than taking content down, which is what legal measures are trying to do. So if we go back to the original distinction that the Council of Europe made between 3 different elements of disinformation and 3 different phases of disinformation, we can see that the legal measures that we have seen focus, by and large, when it comes to the elements, they focus on the message. They focus on qualities of the message to determine what needs to be countered. They engage with elements of the message to decide what can legally be countered. When it comes to the phases of this information, these laws very much focus on the reproduction and distribution of false and harmful content. If we think of these policy measures and task forces, they engage with the interpreter because they try to engage with the public in raising their awareness, in raising their ability to distinguish, to tell the truth and falsity apart. They engage with reaching them out with messages that somehow limit and counter the negative effect of disinformation. This is what public institutions in different ways are trying to do. And what this reveals is that at the moment there is a lack of public measures, either legal or policy-based, that engage with the agents and that engage with the creation of false and harmful messages. Someone is doing something on them nonetheless, but it's largely the private sector. So measures that stem from the private sector, measures that stem from the platform themselves, engage with the production and the agents of this type of disinformation, on this false and harmful content. Clearly, public authorities at the moment have more than one incentive to let platforms take this role. Because it's easier, because they're best placed to do it in an effective and swift way, because it saved public authorities, the difficulty of going through the technicalities of the process of creation of this information. Is it good news? Well, I mean, we do know problems that stem from the private enforcement of measures that stifle freedom of expression online. So this is, if anything, raises even more